Muy buenos días para todas y para
A
todos.
very good morning
Sean
to you all,
bienvenidas y
and
bienvenidos a la
welcome
Universidad
to
Externado de
the
Colombia.
Externado University of
Saludamos
Colombia.
especialmente a
We
quienes
would
nos
like to offer a
acompañan a
special
través de
welcome
las
to those of you
plataformas
joining us
virtuales.
via
Los
virtual
invitamos a
platforms.
ocupar sus asientos
We
para
would now like to
empezar
invite
con
you to
nuestra
take a
actividad.
seat so that we can begin
Esta
with today's
presentación se
activity.
registrará por medios audiovisuales, fotográficos y
This
sonoros y podrá
presentation
ser
will be
utilizado en reportajes
recorded, the
periodísticos y
photographs will be
creativos que
taken,
sean producidos
and
por la JEP,
some of this material
orientados
may be
con el
reproduced
principio de
in
máxima
media materials
publicidad,
by the JEP in
memoria y
order to give
restauración del tejido social de
publicity
Colombia,
and
bien
restoration of
sea
social
que se
fabric
emitan
to
en
Colombia.
territorio colombiano o internacional,
This
de
material may
manera
be published
gratuita o
nationally or
paga, en salas
internationally,
de cine,
either
proyecciones a
free
cielo
or
abierto,
in a paid
televisión
format,
abierta,
on
cerrada, por cable
television,
satelital, TDT,
in
pantalla de
cinemas,
transporte aéreo, marítimo, terrestre,
also in
plataformas de
land,
streaming,
sea,
páginas
and
web,
air
redes
transport
sociales,
screens, as
festivales
well
de
as
cine,
on social
eventos
networks,
académicos en vivo o en
film
diferido.
festivals,
En
and
este
live
registro
or
audiovisual se
asynchronous
contemple la
academic
integridad,
events.
los
We
derechos
will,
al
of
buen
course,
nombre, al honor, a la
respect the
intimidad
right
y a
to
cualquiera de los
the
derechos
good
fundamentales
standing
de
and
los
any other
asistentes.
fundamental
La
rights
JEP
of attendees.
protegerá todos los
The HEP
derechos y la
will
situación
protect all of
individual
the
y
rights and
familiar y
individual
colectiva de los
as well as
asistentes
family and
y la
collective
utilización de su
situations
imagen en los
of these
productos
attendees.
audiovisuales de la
The use
jurisdicción.
of
Por
anyone's
ello, no
images
expondrá
in the
indebidamente a los
HEP's
asistentes
materials will
y en
take this into
consecuencia
account.
podrá determinar qué
And
fragmentos de su imagen se fijarán en los proyectos
accordingly,
periodísticos y creativos que se produzcan y si es
everyone will be given
necesario
the right to
distorsionar su
decide
imagen o su voz con
if they can
herramientas
be
digitales o
included
si
in
incluso
these
es
media
conveniente no
materials.
utilizarlo en los
And
proyectos
if
periodísticos
there is a
y
need
creativos
to
los
their cover
fragmentos
their
en los que
identities
aparezcan los
or remove the
asistentes.
relevant
En un momento
fragments.
vamos a iniciar
In
entonces la
just one
transmisión
moment,
en
we
vivo.
will begin
Muchísimas
with
gracias.
our live streaming. Thank you.
De nuevo, muy buenos días para
Once
todas y
again,
para
a very
todos.
good morning
Es
to you
un
all.
honor dar
It is
inicio
an
a la
honor
jornada
to now
académica
open our
titulada Las
academic event
sentencias de la JEP,
titled
una
JEP
conversación
Rulings,
académica
an
sobre su
academic
significado e
conversation about
impacto
their
en la
meaning and
construcción de
impact
paz.
in
Este
peacebuilding.
evento tiene como
This
objetivo
event
fundamental propiciar un
intends
espacio
to here
ordinario de
create
reflexión
a space
profunda,
for dialogue
gracias a
and
la
deep
invitación del
reflection.
Departamento de Derecho Constitucional de la
Thank
Universidad
also to
Externado
the
de
Department
Colombia.
of
Los
Constitutional
magistrados de
Law
la
for the
Jurisdicción
invitation
Especial para la
here at the
Paz
Externado
presentarán
University.
los
We will be
avances y los
joined by
retos en la
magistrates from the Special
expedición e
Jurisdiction for
implementación
Peace,
de las
in which they will
sanciones
talk about
propias.
the
Asimismo,
challenges
hoy
and
tendremos la
application
oportunidad
of
de
the
examinar el
special
sentido y el
sanctions in
impacto
their
de las
rulings. We will
sentencias
look at
recientemente
the
emitidas por la
impact and
jurisdicción
meaning of the
sobre la
recently issued
implementación del
rulings.
acuerdo final de paz y en
With
general
regards
sobre
to
la
the
construcción de
implementation
paz en
of
el
the final
país.
peace agreement and peace
Finalmente,
building, we will
aspiramos a
hear
entablar un
their
diálogo sobre
reflections.
las
We also
contribuciones
hope
que desde
to have a
Colombia se
discussion
pueden
about
derivar para
the
otros
contributions
procesos
made
de
in
paz
Colombia
y
that
justicia
may be
transicional
important
alrededor del
for other
mundo.
peace processes and
Saludamos muy
transitional justice
especialmente a
processes
Hernando
around the
Parra
world.
Nieto,
A very special
rector de
welcome to
la
Hernando Parra
Universidad
Nieto,
Externado de
who
Colombia,
is the
a
Dean of
Ángela
the
Ramírez,
Externado
directora
University,
ejecutiva de la
Ángela
iniciativa
Ramirez,
Barometer.
Executive Director of the
Damos también la
Barometer
bienvenida
Initiative,
a
and
Steve Hege,
also
director
welcome
del
to
Instituto
Steve Hege,
Latinoamericano
who
para la
is the
Paz y
Director
la Seguridad.
of the
Él nos
Latin
acompaña
American
de manera
Institute for
virtual.
Peace and Security, or
Extendemos el saludo
ILAPS.
al
We would
magistrado
also
Alejandro
like to
Rameli
extend a
Arteaga,
welcome
presidente de la Jurisdicción Especial para la
here,
Paz, a la
Alejandro Ramelli,
magistrada Ana
magistrate
Manuela
at
Ochoa
the
Arias,
HIP,
presidente
Ana
y
Manuela
presidenta de la
Ochoa,
sección de
who
primera
is president
instancia para
of
casos de
the first
reconocimiento de
instance
verdad y
area
responsabilidad,
for
al
the
magistrado Camilo
responsibility and
Suárez
truth
Aldana,
area at HIP,
también de
as
la
well
sección de
as
primera
Camilo Suarez
instancia para casos
Aldana,
de
who is
reconocimiento
also
de verdad y
involved in
responsabilidad.
cases for the recognition
Saludamos a
of truth
Gloria
and
Castrillón
responsibility.
del Instituto
Welcome also to Gloria
Latinoamericano para la
Castrillon
Paz y la
from the Latin
Seguridad.
American
Extendemos
Institute
un
for Peace
saludo
and
muy especial
Security.
a
We would
quienes
like
nos
to
siguen a
extend a very
través de la
special welcome
transmisión
to
en
those
vivo
of you
a través
joining
de las
us by
plataformas
live
de la JEP
streaming
Colombia. Sin más
via the
preámbulos,
HEP's
cedo la
accounts. With
palabra
no
a
further
Hernando Parra
ado,
Nieto,
I would now like
rector
to
de la
hand over to
Universidad
Hernando
Externado de
Parra
Colombia.
Nieto, who is the
Bienvenido.
Dean of the Externado University in Colombia. Welcome.
Muy buenos días para todas las
A very
personas
good
que
morning to
amablemente nos
everybody
acompañan
who
en
has so
nuestro
kindly
auditorio
joined
número
us.
3 del edificio I de esta su casa, el Externado de Colombia.
And
Bienvenidas y
welcome to your
bienvenidos
home
a ella.
here at Externado
En nombre
University.
de nuestra casa de estudios,
In the name of the university, it is a pleasure to warmly welcome you to this academic event, which is entitled The JEP Rulings, an academic conversation on their meaning and impact in peace building. And, of course, a very warm welcome to the Special Jurisdiction for Peace, the President and magistrates who are joining us today. Thank you for visiting us here in our esteemed academic institution for this event. A very warm welcome to Professor Alejandro Ramelli Ordiaga, President of the Special Jurisdiction for Peace, as well as a professor here. Also, welcome to Ana Manuela Ochoa Arias, who is a magistrate at the JEP, as well as Camilo Suarez, who is also a magistrate at the JEP, who will all be presenting today. Also, welcome to other members of the Special Jurisdiction for Peace. It is an honor to have you here as we strengthen the connection between academia and peace building. Also, Paula Andrea Costa, it is a pleasure to also invite you, as well as Mr. Pinzon, a graduate, as well as all of the other teachers and professors who have joined us for today's event. I would also like to make special recognition of our partners here, the Notre Dame University, the Kroc Institute, and the Latin American Institute for Peace and Security. A very special welcome to all of these institutions, because we share here a special commitment to knowledge building and sustainable peace building. We are brought here together for a special purpose, to open up an academic reflection and analysis space to talk about the recent impacts of the JEP's rulings. These legal rulings do not only have legal impacts, they are nothing less than milestones in this path towards truth, justice, and victims' reparations. And I would like to highlight this latter point of victims. We see here an invaluable contribution made to our collective national reconciliation process, which we so desperately need. The university, and more specifically the Externado University, is a space for critical thinking, and we, of course, must provide spaces for these kinds of conversations. Peace, in addition to being, of course, a political, legal, and sacred right in our constitution, is also an ethical, cultural, and intellectual challenge that involves all societal sectors without exception. We must have a harmonious work between public and private sectors. Without this harmonious effort between all of our sectors, we will not reach any goals. And accordingly, we must build bridges of conversation and communication, seek reconciliation, agreement, and avoid polarization. The damage being done to Colombia by polarization is unimaginable. We are responsible for ensuring that we give a country at peace to our future generations, in which nobody is eliminated for thinking differently to us. Tolerance is one of our most important values here at the university. We respect those who think differently, and accordingly, we open up these spaces. Colombia is a country where we can think differently without anybody's lives being threatened. And so here we have students, researchers, political authorities, representatives of civil society who come together in this dialogue with the certainty that when our voices come together, we will find better answers to the challenges we face as a country when it comes to peace. I would like to reiterate my welcome to all of you, Professor Ramelli and the whole JEP team. Thank you for being here. And we hope that this will be a very fruitful academic event that will inspire us to continue to build paths of justice and peace together in our beloved country. Thank you very much. And once again, welcome. You are here. Welcome, and very, very welcome indeed to the Externado University.
Muchísimas gracias, rector, por su saludo.
Thank you very
Por
much
poner en
for these
contexto la
opening
importancia de las
remarks.
decisiones
And here
recientes
we've
de la
heard about
Jurisdicción
the
Especial para la
importance
Paz,
of the
así como
recent
el
rulings made by the
propósito de
Special
este
Jurisdiction
espacio.
for Peace, as well as the purpose of this event.
Ahora invito a Ángela Ramírez,
Now let me
directora
invite Ángela
ejecutiva de la
Ramírez, who is the
iniciativa
Executive
Barometer.
Director of the
Bienvenida.
Barometer Initiative, to the stage. A very good morning to you all. It is a pleasure to be here in representation of the Kroc Institute at the Co-School for International Peace Studies at the University of Notre Dame. I would like to start by expressing my gratitude to the Externado University for opening their doors to us and for organizing this academic event together with the Latin American Institute for Peace and Security, ILAPS. This is an event that seeks to boost or create a space for deep and enriching dialogue when it comes to the implementation of the 2016 peace agreement. Firstly, I would like to thank the president of the special jurisdiction, Dr. Alejandro Ramelli. Also, thank you, Magistrate Camilo Suarez and Magistrate Ana Manuela Ochoa. We are truly grateful to you for having accepted this invitation and for your willingness to share your knowledge with all of us who are here today and who are also joining us online. We are very much looking forward to hearing your valuable reflections on these first rulings. Your contribution to peace building and to special sanctions is invaluable. As you know, point 6 of the agreement left or provided for international verification, and accordingly, the Kroc Institute has come up with a methodology to follow up on the implementation of the peace agreement. And we have been working on this for some time now. We have been rigorously supporting the project. We have supported every advance made and also been very clear when we have seen the persisting challenges involved in the process. Today, we are brought together for the implementation of point 6 of the agreement. The first rulings of the Special Jurisdiction for Peace in cases 01 and 03 mark a true before and after in restorative transitional justice in Colombia. These sanctions open up the possibility to coordinate with other programs in the final agreement, for example, the territorially focused programs of PEDET, as well as the comprehensive territorial reform program. Here we see an opportunity to move forward with more comprehensive and coherent implementation of the agreement. From the Kroc Institute, we have documented the path that has been walked on by the special jurisdiction to reach this point, as well as the perceptions of the victims, the appearing parties, and other stakeholders. The special jurisdiction has 38 commitments, of which 2 are directly related to special sanctions. With the issuance of these rulings, these commitments are fulfilled, and at the same time, conditions are created in order to advance with other key commitments in the final agreement. Now, this space does not only invite us to analyze the true meaning of these rulings for Colombia, but it is also an opportunity to reflect on how our transitional justice model may be used to make contributions to other peace processes around the world. The Colombian model is unique, but I am sure it will bring with it best practices and valuable lessons learned that will be able to serve other countries. Here we will see how Colombia has sought to overcome armed conflicts and respect victims' rights. Hearing your ideas and experiences today will be an invaluable opportunity to continue to move forward with the implementation of the peace agreement. Thank you again for being here and for being part of this conversation, which I'm sure will be very, very useful for us all. Thank you.
Thank you very much, Ángela, for highlighting the importance of the recent decisions issued by the jurisdiction, not just for Colombia and the world, but also for the victims, and mainly for the victims. Right now, we'd like to share a video by the director of ILAPS.
Muy buenos días para todas y todos.
Good morning, everyone. On behalf of ILAPS, the Latin American Institute for Peace and Security, it is a pleasure to summon this public event that will talk about the meaning and the impact for peace building, the coming from the recent rulings issued by the Special Peace Jurisdiction. We want to thank Kroc Institute and our colleagues at Externado University for making this possible. I'm sorry I cannot be there in person, but I have other commitments with indigenous communities in La Guajira, where I'm speaking from. I'd like to greet Dr. Alejandro Romelli, chair of the JEP, also Ms. Ana Manuela Ochoa and Camilo Suarez, both justices. I want to congratulate you for reaching this very important milestone for peace and building in Colombia, and for this initiative to come to the public to share your personal aspirations and your reflections on the transforming impact of these rulings. We, ILAPS are a non-for-profit that has been focusing on working on peace building jointly with our colleagues at Kroc. Our team had the privilege of supporting team in the process of building internal consensus to reach these rulings. And it is thanks through this experience that we have been able to understand what this process has meant and the burden it has carried for the justices at JEP at a personal level and a professional level, especially keeping in mind that the country has wanted to learn what the rulings will be, of course. Now, we generally lose sight of a number of things. It is true that there will be inconformities and that will be listened to in order to continue improving. JEP continues to be the only court in modern history which
que acordaron ser juzgados y sentenciados con todos los estándares internacionales por crímenes de guerra y crímenes de lesa humanidad. Nunca había ocurrido anteriormente en ningún otro conflicto del mundo. Sin esa negociación política entre el Estado
without that political negotiation between the state and the disappeared FARC, the alternative would be a full absence of justice and repair for the victims. Now, in this ruling, we need to keep in mind that what it represents is what was possible at the time in being able to have FARC dismantled. What was agreed upon at Havana was a very ambitious endeavor which seeks to sanction very serious crimes with restoration to heal the pain and the damage, but also punitive in the effective restriction of liberty. The justices that have participated in these rulings were tasked with something that no other judge in the world has had to take on ever, by seeking a balance between these two spirits, of course, keeping in mind the very many requests by very many victims. Along this path, surely there are many lessons learned, and I hope we can keep in mind the symbiosis between what's restorative and what's punitive, both elements that reinforce each other mutually in order to, from a place of symbolism, restore society, and that the perpetrators can reimagine the meaning of what it means to be retributional without losing sight of what this may mean. I now leave you with Gloria Castellón to kick off this conversation, and I hope you can continue to count on us in this community of so many partners and allies of JEP over the course of learning from these rulings and this process. Thank you very much, Steve, for supporting us, even though you couldn't be here in person, for addressing us from La Guajira. Next, we will have a conversation with the participation of Ana Manuela Ochoa Arias, Alejandro Romelli, current chair.
Tanto la magistrada Ana Manuela como el magistrado Camilo hacen parte de la sección de primera instancia para casos de reconocimiento de verdad y responsabilidad de la JEP
They are part of the group of magistrates who here had the task of issuing these first rulings of the JEP. Ana Manuela Ochoa is a university graduated from Los Andes University. She has done a course in human rights in Strasbourg, France, and for several years she has been an advisor to the National Indigenous Organization of Colombia, ONIC, and also the Cancuamo indigenous peoples. She has worked as a lawyer for the Inter-American Court on Human Rights. Alejandro Rameli Ortiaga is a graduate from Externado University with a master's in human rights in France and a doctor of law from the Salamanca University in Spain. He has been an invited professor to many different universities around the world. He has also worked in the Attorney General's office, the head of the Analysis and Context Unit, delegated prosecutor, as well as auxiliary magistrate in the Constitutional Court, as well as an expert before the Inter-American Human Rights Court. He has also published some 40 articles on constitutional law, human rights, and international criminal law. Magistrate Camilo Suarez is a lawyer graduated here in Colombia. He works in conflict resolution with a specialization here in Externado University and has also worked on procedural criminal law here at Externado. He has also looked at criminal constitutional processes and military processes at the Nueva Granada University. He has a specialization in human rights law from the Alfonso X University in Madrid. He's also studied in Germany and has looked at human rights in Israel and Palestine. He also completed a master's in criminology at the Externado University. For 24 years, he was also a specialist in the military criminal court, and he was also president in 2012 to 2013, 2015 to 2016, the same institution. He has studied international humanitarian law and is a university professor. So today's space will be moderated by Gloria Castrillon, who's from the Latin American Institute for Peace and Security, ILAPS. She has a master's in international affairs and conflict resolution. She has worked on policy, human rights, the armed conflicts, and has also worked on peace negotiations with FARC-EP and AUC. She is a consultant on armed conflict as well as historical memory. She has also been the director of Colombia 2020, which is an educational and journalism project with El Espectador. She has worked also with the article writing session looking at how to narrate on peace and memory. And she's also written the book 12 Lessons that we have learned from the war and works on post-conflict. She will be in charge of guiding today's conversation, in which we will talk about the legitimacy and participatory building, as well as balance between components, verification, compliance with, and lessons learned, as well as best practices for transitional restorative justice. We have handed out these little booklets here as you've come in. This has been a gift from the JEP. So please note down any questions you might have. And a team here from the Externado University will collect these questions to ask them to. And so let me now hand over to Gloria.
Ya, qué pena, es que no me cerró la puerta y entonces, en fin, pero ya estoy aquí con el otro backup. Thank you.
Bien, buenos días.
Very well.
A quienes nos acompañan aquí en la Universidad
Good
Externado de
morning, and
Colombia.
thank you for those of you who are with us today in person here at Externado University in Colombia. I graduated here from my master's degree. So, dear President, it's a pleasure for me to be here again. We also want to greet the people who are joining us online via social networks and the different platforms at JEP or JEP. And also those of you who are joining us via the Kroc Institute's streaming from different places in the world. I know we're joined by professors, teachers, scholars, and of course students who are interested in the Colombian case and application of and the process of applying transitional justice in Colombia. We're going to be getting questions and hearing questions from the audience here in the auditorium and also via YouTube from people in Colombia. And also, hopefully, if there are questions coming in from abroad, we hope to be able to take those too. Of course, after listening to what the magistrates have to share with us today. Thank you to ILAPS also for making this possible. And first, I'd like to yield to Alejandro Ramelli, the JEP's chair, for him to give us some context on the two sentences that have been issued. A few days have gone by since they were first communicated, but we've been able to settle down a bit. And we'd like to hear from you, Chair, on what your vision is on the context of how these two sentences are coming about. Well, good morning, everyone, and thank you. It's a pleasure to be here. Mr. President of Externado University, thank you for having us and for hosting us, also to Notre Dame, to the Kroc Institute, ILAPS, our colleagues, Camilo, Ana Manuela, other staff from the Special Jurisdiction for Peace. I'll try to be brief in my remarks. I had put together a slide deck. If you can backtrack a bit. Okay, let's see. So basically, this is a teaser of sorts of how the cases are moving forward, cases 01 and 03, and then my colleagues will refer to the ruling specifically. The 01 macro case related to abductions and kidnappings is one of the different macro cases. You think that the sentence or the ruling is the final part, but it's just really a small portion of the entire process. There are several macro cases related to FARC's activity, and you're seeing here the general case for the ruling issued by the magistrate Camilo. Here we're looking at abductions and kidnappings, but then there are going to be rulings for the other micro cases. So this is just the very beginning, the first decision that has been issued. And it's just, again, as I'm saying, the beginning. Look, if you look at this macro case, we've done what the Colombian justice never managed to do, which was to investigate the middle managers or leaders at the different FARC blocks. We have been investigating their doings and their participation in different territories across Colombia. And this is just the beginning of many other rulings. You know, we're talking about 21,325 victims, many of them accredited, other perpetrators or appearing parties, and 10 decisions on facts and conducts, which are micro accusations. And if we look at case 03, it's just a small decision as part of case 03, the 03 macro case. And this is the first ruling. What you're seeing here in the different regions, Huila, Casanare, Dabeiba, Meta, and several other regions, they are still to come. So this is the first decision for just one region. So look at how it's important to insist on this is just the tip of the iceberg. The first rulings to be issued of many that are to come, and not just for macro cases 1 and 3, but for all other macro cases up to the 7th one. And of course, we're seeing the universal or the universe, the provisional universe of the facts, which some are seeking to destroy with some of the figures, which should be another discussion. But we're talking about 4,223 victims, many of them recognized, many of them to be recognized, and we're talking about 252 family members of accredited victims, 12 that have been sanctioned. And so why this case? Why is it that I say that this case is a representation of the entire system? Because it's broken down into several different parts. And look at how this part of the sentence is for 135 events, the dialogical process for 12 people who have been sanctioned. In the adversarial system, 3 did not accept. In the definitions chamber, there are 130. That's why this case showcases the complexity of what we deal with. So in this provisional universe, some accepted or admitted, some did not. Those who did not admit are still in a process, and those who did are in what we're calling the definitions chamber, and everything is being resolved. So that's the entire case. It's not just the 12 sanctioned individuals. And look at the before and after of macro case 01. And I'm going to focus mostly on the before for Camilo to refer to the after. So let's look at what they had before this ruling in Colombia. And I'm going to say this very, very clearly. There were 59 sentences for kidnapping, all with jail, and none of them were ever made effective. None of the sanctions issued in the ordinary justice system, none of them were met in Colombia. They did not spend a single day in jail. And this must be said. The accused were absent during the proceedings. The victims were not repaired, and this is what ordinary justice does. That's what we had. So, yes, there may be many comments, a lot of criticism around the ruling, but let's first focus on what we had before, which was basically nothing. We must tell it like it is. We had nothing. Sentences that were never really met, where the victims never really partook. And so people are saying, well, the victims aren't happy with this ruling. Well, it's wonderful to hear from the victims. We had never heard from them. We hadn't heard the victims of abductions and kidnappings. Never had they been in Bogota for 3 days facing the high command of FARC. And today, now we're talking about the middle leaders in the regions. Never had they faced the victims either. So where do we have impunity? In the ordinary justice system, not at the jurisdictional, the provisional jurisdiction. And it was never known that there were these macro patterns. And so why did it take us so long? We're talking about 21,000 abductions. Again, 21,000. And this ruling is not just against the abductions. No. As Dr. Camilo will point out, we're talking about 13 international crimes. We have undertaken investigations like they have never been undertaken in Colombia. And we are the ones who are investigating FARC in Colombia. Never had FARC been so exhaustively investigated. And if you look at the La Popa battalion, some had been condemned, but 3 had never been even investigated. Of the 12 condemned, 3 weren't even looked at ever. And those who were indeed investigated and sanctioned, some of them were given 40 years in jail. And today, they will be paying what we call sanción propia, or own sanctions. So who is this benefiting? They had jail, They were in jail. They had been put in jail. They were going to pay 40 years in jail. And today they're going to have to repair the victims. But there was a pact of silence of sorts. So what was the state of affairs before? People who had denied what had happened, victims who never were repaired, and people who were never even looked into. So again, that was the before. Did the victims know the truth of what had happened at La Popa? No, they did not. Because again, it was only a pact of silence that had to be broken and is now being broken in Colombia. I want to refer now briefly to the restorative efforts. Of course, there are difficulties. It's hard to design these projects. We've been working on designing them for many years now, many years. When has or had a judge in Colombia ever worried about their ruling really being feasible? Judges, they issue rulings and it's someone else's problem to take care of. But at JEP, we have been working with the victims and the authorities in building these projects. And now what they need is financing, and the government has to finance them. It's part of the National Development Plan and the national budget. It's on the government to finance these efforts. So whether or not the rulings are met, that depends on government. And we've been saying this for many months now. It is on you. It is your responsibility. We need political will for this to happen. I actually sent a communication which was made public, and I'm still waiting on an answer. This communication was addressed to the government. Where is the money, I wonder? So let's look into that. And that's what is being discussed currently at the UN's Security Council today, as we speak. And what are they saying? That the government has not met its commitments. The special peace jurisdiction did meet its commitments. We were in New York in July, and we said we're going to be issuing these rulings, and we did. We met our commitments. So who has the ball in their court now? The government. So there's also, well, the issue at the Security Council. If you are to tune into their sessions, you'll see it's quite complex right now.
So let's look at the panorama. But let me just, let's leave that to the side and let's talk about the rulings. As a jurisdiction, we have made a commitment and we have fulfilled our commitment. And I went to the Security Council and I told them about that. And they said, yeah, this all sounds great. It looks great on paper, but we want to see rulings. And I said, well, here they are. But the fulfillment of our compliance with these rulings is a state issue. All of the effort that we have made to investigate these crimes in a way that crimes had never been investigated before, to ensure that victims could participate in a way they had never participated before. If we do not have the national government support, if we don't have support from all of the relevant government secretariats, we will fail, and it won't be our fault because we have done what we had to do. This is the Colombian state's responsibility. So I won't bore you any further, but I would just like to make those warnings. Okay, thank you very much. Now we will hear from the two magistrates involved in the two rulings. I know there's a great deal to talk about. The rulings have many, many elements that the country still needs to try to understand and digest. But I would ask magistrates if you could please take a maximum of 4 minutes to explain the most important points of these rulings, perhaps what you think has not been yet addressed in the public debate, and then we will have time for questions from the public. Perhaps we can start with Magistrate Ana Manuela. So what points of the La Popa ruling would you like to highlight? First off, a very good morning to you all, and thank you for joining us, and thank you for your interest in Colombia's peace. So I would like to talk about some specific elements of the ruling. I think that this is an innovative ruling when it comes to its content. There are 4 chapters to this ruling. The first talks about the macro-criminal phenomena. So that's the result of our investigation that was done in the chamber. And there are many, many elements that can be extracted from that. So the chamber reached the conclusion, and this is of course based on our investigation, that these were not isolated events. And we here conduct our investigation based on macro-criminal patterns. And here we decided that in this specific case, which was in the La Popa battalion in Cesar in the south of the Guajira, that here 335 people were murdered. And there were 2 macro-criminal patterns here. First, there was a macro-criminal behavior here, and this was done, let's say, in partnership between the paramilitary groups and armed forces. And secondly, we see that vulnerable individuals were removed from the Cesar area and then killed in La Popa. So the first chapter addresses the macro-criminal patterns, which leads us to conclude, and this was already mentioned by our president, that there had already been convictions in the area, but those convictions were not based on coordinated investigations. So the investigations of these crimes, as conducted by the ordinary justice system, focused on individuals rather than groups. And these are not isolated crimes. These are war crimes, crimes against humanity. And I think something that must be highlighted here is that here we are talking about systematic crimes. So that's related to the macro-criminal patterns identified. Then there is a chapter on individual criminal responsibility. The 3rd chapter refers to restorative transitional justice. And I think that this is a very, very important chapter, because we can see how the special jurisdiction for peace, he has to analyze the harm based on our investigations. So this is done in the recognition chamber, because here I believe that really everything is here based on the investigative process conducted by the chamber. And here the harm is not a one-to-one relationship between fact and harm, nor is it about individual harm. It's an illustrative harm based on the facts that were heard by the chamber. And here we can see this leads to systematic harm. And then we have a very important chapter on special sanctions that we can talk about later on, because here we have restorative sanctions. And these sanctions have been widely discussed in the country. And lastly, I would like to talk about the process. Members of our society are accustomed to thinking that the final destination is the most important part of what we've done. So that's why we focused on the ruling so much and we've forgotten about the process. But here I think we must highlight the process that has been conducted here in order to reach these sanctions. And so there are several points within the ruling that must be highlighted. But I think that one of the most important issues here is the process that we engaged in. And above all else, I would say that it's very important that we have here arrived at special sanctions for international systemic crimes. Okay, thank you very much. So perhaps Magistrate Camilo, you could talk to us about the ruling for case 01. Thank you very much, and it is a pleasure to be here at this academic institution. So I would like to respond to your question looking at 5 perspectives that we believe need to be understood in this ruling. This is a ruling which establishes responsibility for those who committed the most serious crimes as part of the armed conflict. And there are here war crimes and crimes against humanity, which are, of course, international crimes. So, of course, we have the taking of hostages under international law, but we also have concurrent crimes. And the ruling also resolves an international debate, which is the connection here between war crimes and crimes against humanity. This has been very clearly developed in the ruling, and in the ruling also makes reference to or has a proposal here that focuses on avoiding impunity. Here, the ruling also guarantees victims' rights. So the ruling here makes reference to the most serious crimes, the crimes that the victims suffered across the country, and also identifies 3 specific patterns of behavior. There was a hostage policy within the FARC that we can explain later on, but this ruling provides an answer based on truth, justice, reparations, and guarantees of non-repetition. Thirdly, this is a ruling that provides legal security to the appearing parties. So here there is a sanction, which is, of course, consequential with our regulatory framework and our peace project. And here, it's a judgment of responsibility, of culpability, and an ethical judgment on their behaviors, but it has also legal security for them. The ruling also resolves several issues related to participation in politics, and also related to the issue of discounts for advanced work performed over these 7 years. Here, we have to look at international standards. As a special jurisdiction, we look at several sources of law for our ruling. We have international human rights law, international humanitarian law, international criminal law, and other sources. And we have to, of course, harmonize all of these, always turning to the principle of legality, ensuring legal security, while we also comply with the requirement for investigation, judgment, and ruling. I also believe that the ruling should be fully understood as a ruling that makes a contribution to Colombia's peace. Here we are honoring what was agreed upon in the peace agreement. We have here many decrees related to the final agreement. The ruling here cannot be understood only as a legal ruling that resolves a conflict, which may be our initial understanding of it. It is a ruling that has to be understood as and also read as something that makes a contribution to prospective justice. We are here judging the past, but also trying to create a better future in every single line of the ruling. Thank you very much. So here, I would like to emphasize one of the last things that was said by Magistrate Ana Manuela. As a journalist and as a citizen, I'm very concerned by or very interested in knowing what has happened, let's say backstage. But you talked about the process. But here we are discussing results. It's not about if people liked this or not, but this is a process that you've been engaged in for several years that we are not familiar with. So here, I think each of you has mentioned this in your own way in your interventions, but this is a dialogical process. Here, the dialogue has been with appearing parties or perpetrators, victims, as well as other magistrates. And so I would like to know if there has been also a full dialogue with the communities where these restorative measures will be taken. And so, what are the parts of the process that we have not seen and that I think would be useful to talk about today? And let me, if I may, add one more element. There's also the ethnic approach in the case that you worked on. The first thing you have said is very, very true. This has been a path. And as we heard from President Rameli, there is a before and an after. So, of course, we worked based on the final peace agreement, and we've also worked in the recognition chamber. But sometimes we forget to reflect on the fact that we have lived in a situation of war for 50 years. Many of our investigations in the Special Jurisdiction for Peace are based on files and more files and documentation of this 50-year-long armed conflict. When I came to the JEP, we were visited by a prosecutor who said that if he had to just send us all of the files related to the armed conflict in Colombia, that it would more than fill the building where we operate. And the JEP is a 12-story building. And so I'm talking here about also investigations conducted by the Special Jurisdiction for Peace. So in our processes, what we receive from the recognition chamber, we're not talking about something that's just 200 or 300 pages, which is what is considered a long file in ordinary justice. We receive legal files of close to 500 pages. And they are focused on 500,000 pages. And as the recognition area, this is what we have to revise and verify. In the recognition chamber, our first task is to look at what's been done in the recognition chamber, so that we can see if due process has been guaranteed and to see if the corresponding rights have been fulfilled. So we receive here complex and incredibly long files. And additionally, we also hear of the victims' constant insatisfaction. They are dissatisfied with the ordinary justice system. They are dissatisfied with state institutions, and they are also dissatisfied with the lack of resolutions from the recognition chamber. And they are looking for us to resolve that dissatisfaction. So we are dealing with very complex processes with a huge number of victims, 135 murders in this area of the country and 2 patterns of criminal behavior and all of that dissatisfaction. So the first thing that we had to do as a section was to look at how we could address the dissatisfaction of our victims. And one of the things that happened to us is that in the section procedure, we did not have an article that would oblige us to have victims participate. And so one thing that we did, which I believe was very important, was to work on victim participation during the whole process based on certain principles, the principle of victim centrality above all else. So we said this is a principle that permeates all of the special jurisdictions' actions, and accordingly, we have to make sure victims are included. And of course, the gender approach, the woman, family, and generational approach, because it's not only about gender, we also have the territorial approach. And one thing that has happened in this subcase is that many of the actions that were conducted were done out in our territory. For example, the verification hearing, the resolution hearing was held out in the territory. And so we also had to look at the ethnic approach relevance here. And many of us who have worked in the indigenous movement and indigenous organizations, well, oftentimes notifications received were not responded to for 24 hours or several days, and they respond in their own time. So we knew that it was necessary. We needed to work on a way to properly notify the authorities.
Una de las víctimas, como lo decía el presidente, un grupo de víctimas es Cancuama, otras del pueblo Huigua específicamente. También tenemos víctimas de 2 consejos comunitarios, uno ubicado en Barranquilla, en Luruaco Atlántico, y otro en el Cesar.
We are here working in Cesar and with several indigenous peoples. We had to, of course,
issued an important decision, we had
those
to go and
notifications
notify
with ethnic.
the communities. And of course, this took us a long time. The other effort that was undertaken to arrive at these sanction projects was to ensure that they were meaningful for the victims.
Tratar de identificar cuáles eran ya en sede de juicio, porque es muy posible que en la sala
at the, say, sentencing level, because maybe in the chamber or the courtroom, the objective is to hear and listen. But once we went through that judgment process, we went to review the different pursuits and aspirations. And this we did by synchronous listening. The victims had already spoken up and said that what they wanted in representation and for reprieve. They also asked that we don't ask them again. So we did what we called synchronous listening, which has to do with listening to the victims and the hearings and all those different spaces where they had participated, to be able to keep in mind those demands for reprieve. So these demands for reprieve were analyzed from 2 different perspectives. On the one hand, a perspective in which the help had no jurisdiction or domain, so we transferred those. We also listened to some demands or requests that we thought we could drive as the special peace jurisdiction instance, so that once we came to the ruling, we would in the end not be issuing the orders, and rather try to solve them as we went. And I think that's a different way of understanding the administration of justice and justice itself. As we were saying earlier, we cannot leave the victims just waiting 10 or 20 more years for someone to come around and solve the situation. So we wanted to start to solve ourselves. So we went seeking for disappeared persons, orders related to inclusion in the single victims registry, because most victims of false positives were not included in the single registry of victims. And we also heard some other comments related to contributions to truth and for truth. Many victims wanted to know how their family members and their loved ones had died, in what conditions, and that led us to ordering what we called restorative practices, where victims and perpetrators sat down to hear what had happened to their family members. And this not for the macro case, but rather more as a healing initiative, healing which many victims needed at the time. And last, a group of demands for reprieve that helped us identify what projects could be included as part of the special sanctions, or what we call in Spanish, sanciones propias. And so we started to listen to the objectives, and that's how we were able to identify 6 different projects that were included in the ruling and are the projects that the appearing parties will be undertaking in the territories of Afro-descendant peoples, indigenous peoples, and some campesino communities that are victims. Thank you very much. Justice Camilo, in the macro case that you heard, is there any process related to transformation that you may have observed in that dialogical effort between appearing parties and victims? Can you tell us a bit about that? I'm sure there are many things that have not been shared in that regard as of yet. I'd like to point out, and thank you for your question, that in building a macro case and given our scope, we were looking at a criminal event and phenomenon that has to do with the resolution of conclusions and macro accusations that, well, have to do with a macro case. And in that specific situation, we heard about 450 different versions in the investigation phase to come to the conclusion that there were 7 people who were responsible. And what you're asking, I think, is very important, and it's very important to keep the following in mind. This was pointed out by the chair in the beginning, or the president. It's the first time ever in the history of Colombia that the FARC's high command, or secretariat, is condemned. This had never happened before. There had been some condemnations or rulings that had not been complied with nonetheless, and we are contributing with the truth. They are admitting responsibility, and they are submitting to a justice system. It's almost exotic, if I may be allowed to use a term, for an armed group to demobilize after 54 years fighting to submit to justice. So that's a true transformation if you think of the will to appear before a judicial process, assuming and taking on responsibility for what was done, and with the intent to restore or repair the victims with a permanent will. After 7 years submitted, because they had attended different hearings, restorative circles, private encounters for truth contribution. As the doctor mentioned, we designed a process for victims to participate where they were present, and they are now committed in complying with the sentence. Also, accepting their own responsibility for each and every one of the crimes. As I mentioned already, I'm talking about 13 different international crimes. Also, to look at people who confronted the state, committed crimes of war and atrocious crimes, to admit the responsibility and the will to repair the victims as part of the transformational process. The other scenario, which is quite powerful, is the willingness and the availability of the victims for many years, and Ana has referred to it. We've had very specific experiences of sometimes events that happened 10, 15 years ago, where victims feel heard for the first time ever by a judge, since they are able to constructively participate in the presentation of the reports, in building and rebuilding the facts and the truth directly, and also by participating in what has to do with constructing or building the restorative projects and the sanctions. and the application of those sanctions. Just yesterday, I think you remember this, there was a meeting at JEP where we were talking about how victims have been transformed for obvious reasons and only understandable in the beginning. There was a great deal of hurt and pain, but this process has brought about reconciliation instead of hate by understanding the perpetrators and those who are appearing before the court and being able to confront them. This too brings about a certain transformation in the victims. And of course, there's a lot of very valid criticism from some victims, but they are not most of the victims who have been victims of very complex and painful situations. They have said that thanks to the special jurisdiction for peace, certain patterns have been revealed, criminal patterns have been revealed, and they've had a chance at truth and reprieve. Restoration in this special jurisdiction for peace is not just the projects, but also listening, acknowledgement, and being able to participate in these processes. Even before the rulings, many of the victims have said, I already feel that I have been repaired just by being listened. And again, as we've said, the ruling is not the end point, but rather the beginning. And I think it transforms us all, even us as judges. In my case, a criminal judge like myself, having been so for 30 years, can change as part of this process. It has happened to me. And then what we call retributionism, from the point of view of the sentence. We are trained in this idea that effective justice means incarceration and custodial measures. But I think retributionism is in the middle of a crisis, especially if you look at penitentiary system or jail system. Because it's not just about taking on the criminal responsibility, but to try to reprieve and repair the damage and to, again, repair it, as I've said. I'm going to share an opinion, if I may. As a journalist between 1998 and 2002, I had the chance, I would say, privilege of covering the peace conversations in the Caguán region. And it was the first time ever that journalists got to meet members of the FARC command and middle-level commanders face to face and to talk to them. And there's a very big step from back then when they used to call abductions retentions and extortion. They used to call it taxing. I don't know if you remember Law 002. If you think of that and think of, where they are at today, where they are recognizing everything they did and giving it a name. Of course, I'm not defending any one of those actors, but as a citizen and a journalist, I do think there has been a transformation, and that ought to be kept in mind. If we think of when they justified abducting elders and children and never ever admitted to doing it back then, to having abducted these people. So, of course, and again, from my viewpoint as a journalist, I'm sure other colleagues would agree, we've seen reactions in the media of victims in the 001 macro case that have expressed being disappointed. I wonder what your view is on that. It's the first ruling for the first macro case. What else can happen as part of this process for there to be less resistance or pushback? Is it possible to admit all demands from all victims in that universe, Chair? Well, thank you for your question. In looking at the observations and comments and reactions, I think they all need to be taken, I guess, from different vantage points, depending on where they're coming from. Some reactions are simply against the peace agreement. So it's almost like reliving the debate from back in 2016 and before. Why not jail for these people? How long have we explaining that there won't be custodial measures? And it's contained in the peace agreement. It's not new. So I just say this because many of the comments are not even referring directly to the ruling, but simply to the peace agreement and the disagreement with that agreement. So since the very beginning, they weren't in agreement. Of course, they were not going to be in agreement with the ruling, regardless of whatever it could have been. Because the ruling could have contained anything, and still there would be critics. So there's nothing to do with those comments. But then a few others say, why so lenient, the sentences? Again, I have referred to those sentences that were never applied. But let's think about how wars have always ended in Colombia, ended up from ever since the 19th century. They always end up in amnesty for everyone. In the situation of amnesty, there aren't any judges, no damages to be reprieved. And the truth is that all wars in Colombia have ended in amnesty, and no one spoke up against that. So we need to keep in mind this history of ours. Also, from a more personal perspective, of course, we understand the pain that the victims have gone through. Anyone who had to spend 10 years abducted in the jungle, of course, would have a lot of pain. And you can rest assured, we did our best. We put in our best effort to listen to the victims. Many of them came to the court, were part of the hearings. I'm not going to name any names, of course, but they were there in the hearings, in different sessions to share versions, and that's the model. Now, of course, if you were to put yourself in their shoes, no ruling would put their minds and hearts at ease. No ruling whatsoever. I'd even dare propose this debate. If you were to be told you're responsible for 21,000 abductions, what would be your sentence? Not even the United States, where you get, I don't know how many life sentences. So what sentence may be deserved by someone who is guilty of 21,000 abductions? Let's think about it. Death sentence? That would be 10, the death sentence and 40 more years. And does that make sense?
And what the judicial apparatus can do is recognize victims and provide explanations as to what happened, receive explanations they had never received before. And so, when I had these victims previously sat down across the table from the higher commanders in the FARC, never. It's very painful. Let me share an anecdote and then I'll stop. And this was heard by Magistrate Juliet. And so a member of the FARC secretariat was very affected by the hearing. And he said, if I'd have known this would be so difficult, I would have preferred to go to jail. Said by a member of the FARC secretariat directly. It's not easy to sit down, to appear before a country and recognize your responsibility. And so I understand. And victims here have had a chance to sit down with the perpetrators. And I think that when it comes to what we can do as the jurisdiction, we have done everything we were charged with doing, and we've gone even further. And we've had to do all this in a very polarized environment. We are in a presidential campaigning period here in Colombia. And so I don't know if there is a real proposal to fix this polarization in the country. And so here, our commitment is to continue to work, to continue to give the best of ourselves, to remain fully committed, and also taking into account the emotional weight that we carry with us. We have heard all of these stories. That is no easy task. We have had to deal with risks and debates. Imagine if we'd had proper support for this. Imagine with everything we've managed to do without report, we're still going to do what we needed to do. Imagine how well we would have done things had we had proper support. Okay, we've already received several questions, and we are trying to group them so that we can respond to the majority of questions. But there are three questions that make reference to the victim's needs and emotions. And here, there's a reference made to tensions between the JEP and Law 1483. Sorry, Law 1488. And then we have another important question, very, very similar, which is how we can guarantee victim centrality in the JEP. You've already spoken about that. But we know that it doesn't matter how many times we explain this, it's a question that will come up again and again. I would like to take advantage of this question to talk about something specific. The special jurisdiction for peace is part of a system. And we do have Legislative Act 001, which makes reference to the reparations, truth and non-repetition justice system. Remember that we have extrajudicial and judicial agencies. We have here the Truth Commission, the Searching for Disappeared Persons, and the JEP. But here, there's a very important reparations component, and that's where Law 1488 is involved with regards to the victims unit. But there is a specific issue here. Here we cannot give reparations for any damage to private assets, nor can we be involved in other judicial aspects. We have a huge challenge here, because in case 01, we are talking about more than 4,000 victims, and we have 116 lawyers involved. That's a litigation. So we spent more than a year hearing these judicial cases, responding to appeals, but there was a lot of prior work done. There were technical working groups, and we also had decisions that we issued so that the victims here can be incorporated into the sole victims registry. But the idea is, of course, to ensure that we have comprehensive reparations. But here, we are not responding to any issues related to assets. So here, there are no financial reparations. So law 1488 does come into play here, and we have activated it for recognition and reparations. And here, both direct and indirect victims can be included. Victims of the armed forces can be included. That's to say, all types of victims can be addressed. So for us, this law is not foreign to us. And here it's all about victim centrality. So here it's about complementarity of the restorative aspect. I don't think there are tensions. I don't know if my colleagues would agree. We have a regulatory challenge here. When we look at Law 1488, the victims accredited by the JEP can be included in the sole victims registry. And here we've had orders that have been issued by the jurisdiction to do that. But above all else, we really honor our dialogical principle. So in our procedure, there is a verification hearing, a prior hearing that's held. And this is also working with our technical working groups. And the victims in these hearings have been able to ratify what has been said. This happened in case 01. So they said that they had not completed many bureaucratic procedures because that would have slowed them down when it came to being accredited as victims. Magistrate, in your case. And so here, how do you ensure and fulfill this victim centrality? Let me talk about victim centrality. I come from a world in which decisions are made collectively. A world in which one person doesn't make unilateral decisions. And I've been involved in assemblies of up to 20,000 people. So for me, participation was not a new idea, nor was the idea of punitive measures, or how people could also fulfill sanctions outside of prison. In the indigenous world, all of this is normal. Participation, decisions. And I think we've brought that with us to the jurisdiction. So those of us who've worked with indigenous peoples, there are 8 of us in total, have really focused on these aspects. And so I also came from a world in which people said, look, we don't want this to be something that's just written down on paper. We want it to be real. And so those of us who worked in this section have really focused on this. We've insisted that the principle of victim centrality cannot be something that's just written down on paper. This had to be made into something material. It had to be real. And we've said this from the very beginning, not only by making the decision, but also by going out to our territories and listening to what victims were requesting. To guarantee this principle of victim centrality, we focused on the principles of transitional justice and the special jurisdictions justice model, but we also looked at the essence of restorative justice. Restorative justice basically says that victims and perpetrators sit down, they engage in a dialogue, and they have to decide how reparations can be made, how these harms can be repaired. And so we turned to the model itself, and this is what really helped us to guarantee victim centrality. And we also turned to a restorative practice, which are the sentencing circles. This is basically a practice derived from a Canadian judge, Barry Stuart, and basically you sit down, you listen to the parties, And based on that
redactan la
listening,
sentencia o llega la decisión
you
de la
write the
sentencia.
sentence.
Nosotros también tuvimos, por ejemplo, muy presente que las órdenes
And
no las
we
podíamos construir al final
also
del
knew
día, cuando
that
estuviéramos ya
our
cansados de
judicial
escribir los
orders
hechos, el derecho, entonces
could not be
íbamos a
left
construir las
to
órdenes.
the very
Las
end.
órdenes se fueron construyendo con las mismas
The
víctimas.
orders
Y si uno
were
lee la
created with the
sentencia, por
victims
ejemplo,
themselves. And if you
hay
read the ruling,
solicitudes que fueron expresas
there are
de las
requests,
víctimas, las
express requests
solicitudes de
from the
reconocimiento,
victims,
se solicitaron
recognition
más
requests.
prácticas restaurativas,
Also, more
la
restorative
solicitud de
practices
tener
were
un día que
requested.
conmemore el Día
There was also the
Internacional de
request
estas
to
víctimas.
have an
Entonces yo creo que
international
se
day to
garantiza es
remember these
haciéndolo,
victims.
¿sí?
And so the
Eso
guarantees
lo
are
que creo.
provided
Y en relación
or
con
fulfilled by
la
acting.
armonización, pues nosotros desde el principio, como lo decía el magistrado Camilo,
And as we've
dimos
heard
unas
from
órdenes
Magistrate
para que
Camilo,
se
we also
activara el
issued some
componente
orders
de reparación integral.
to
Tuvimos que
activate
dar estas
comprehensive
órdenes a la
reparations
guardia.
measures.
La
We had to
verdad,
hand this
yo
over
tengo que
to
decir que
the
no
Wadi.
estoy tan conforme con los avances. A
Eh,
algunas víctimas ya se les ha
Some
reconocido,
victims
ya están incluidas en el RUT,
have
pero
already
se necesita
been
más. Se necesita
recognized
ser
and been
más diligentes en ese sentido,
included
porque aquí las
in the
víctimas
sole registry,
ya
but we
son
need to
muy
be
mayores. Fíjate, son
diligent
víctimas que
here
llevan 20
because
años.
we have
Este es un
victims here, some of
hecho
whom are very
ocurrió hace
elderly.
22 años. Sí,
These crimes
los
occurred more than
jóvenes hoy
20 years ago.
tendrían 40, 50
So those
años
who were
y
young when they
pregúntense qué edad tienen
suffered
hoy
these
las niñas.
harm
Y cuando vamos a
are now in
hablar
their
de los
40s.
proyectos restaurativos, muchas
And when we
nos
look at
dicen,
restorative
la pregunta de
projects,
ellas es, ¿será que yo sí
many
voy a
victims
ver
say, do you
esta
think
casa?
that I'll
¿Será que yo sí
actually
voy a ver
see
este
this
proyecto?
house be
Entonces yo creo
rebuilt?
que
Will I see the fruits of this project?
hay que recurrir también a los criterios de
And
priorización
so we have
con
to
estas
also
víctimas
look
que llevan
the
tanto tiempo
prioritization
buscando
criteria
que
that
sean
applies
queridos desaparecidos o
for these
buscando
specific
justicia en este
victims who
país.
have been seeking
Una
justice in this country for so
acotación
long
pequeña
or
para aprovecho
seeking
para una
their
pregunta que hizo
disappeared
una
loved
persona
ones.
aquí en el auditorio.
I have a
¿Por qué
question
este
here from
caso
someone in
no
the
había sido
auditorium.
investigado antes?
Why had this case not been
Seguramente sí, no sé
investigated
si usted nos quiere
previously?
aclarar si fue
I don't know if
investigado
you would like
antes
to
en tiempos
clarify
de la
if it
justicia
was
ordinaria, por favor.
investigated previously, perhaps
¿Qué
in the
información
ordinary
nos puede dar al
justice system.
respecto?
What
Yo
can
creo
you
que
tell us about that?
lo dijimos al principio.
I
Es
think we
decir,
said this
en
at the
este
beginning.
caso,
In
sí
this
habían
case,
habido unas condenas. De
there
estos
were
12
some
máximos
convictions
responsables,
made
solo
for
3
those
fueron el
responsible for these
resultado casi que de
crimes.
la investigación que hizo la
And
Jurisdicción Especial para la Paz. Los
only 2
demás
new
estaban ya
perpetrators were
condenados
identified
o
in the work done by the
privados de
JEP.
la libertad en la
Others had
justicia
already
ordinaria.
been deprived
La
of liberty
diferencia,
or sentenced in the
eso es muy
ordinary
importante,
justice system.
es
But the
que la
difference, and this is very
investigación que hace la
important, is that
jurisdicción
the
es la que
investigation
ya lleva
conducted by the
a
Special
concluir que
Jurisdiction
estos
for
son
Peace
crímenes de sistema, que son parte
leads
de
to the
un plan,
conclusion that
que
these are
que no son
systemic
aislados,
crimes.
que
They
no
are
son
part of
azarosos.
a plan. They are
Eso,
not
eso
isolated.
creo que es lo distinto que hace esta jurisdicción especial
And I
para la
think that's
paz.
what different, that is what is
Antes,
different
muchas de
about
estas personas habían sido investigadas por
this
asesinato, en persona
special
protegida, desaparición,
jurisdiction. So previously, these crimes in many cases had been prosecuted because of people of political interest or vulnerable people had been murdered. But these crimes are not being prosecuted as crimes against humanity. And so when you move from ordinary justice to the special jurisdiction for peace, the model itself changes. So here we arrive at the conclusion that these are crimes against humanity and that they are part of systematic patterns. And what's more, there's this whole restorative process that has been implemented by the special jurisdiction.
My next question is for you. There have been appeals and surely more will come for the sentences. So how are they going to be kept in mind when it comes to restoration projects and processes? Who wants to go first? I mean, it's up to you.
En efecto, en estos momentos ya hay apelaciones
So
a la
currently,
sentencia.
yes, there have
Y
been
nosotros hemos
appeals
estado
to the
pensando
sentences.
cuál es la mejor ruta para
And yes, we have been sitting down and
avanzar con los
thinking
proyectos
about what
restaurativos,
path
entre
we
otras,
should
porque hay
follow
proyectos
to continue to move
restaurativos, por
on with
ejemplo,
the
en el caso
restorative
Copa, que ya
projects,
tienen
because there
recursos
are
disponibles para
some
este
that
año.
have already
Por
earmarked
ejemplo, los
resources, like
proyectos
for
que está
the La
previsto
Popa
realizar
case.
allí
One project
es,
to be
hay un plan de
undertaken, La
memorialización para la
Popa,
costa caribe.
has to
Dentro de
do
ese
with
plan de
building
memorialización estábamos pensando
a
la construcción de
historical
700 osarios
narrative and with different ossuaries at the cemetery. And one of the paths that we think is possible is to have the appearing parties be a part of these events so that they can start to add up towards their sentences. There have been some what we have called discounts, meaning that they have already paid part of their sentences and that we don't have to wait 6 months for the resources to be earmarked. But again, it depends on what the appearing parties may want.
Quisiera señalar por supuesto, la sentencia también tiene ya apelaciones.
Yes. So I would like to refer to the fact that there have been appeals already and the terms are about to expire.
Realmente no son muchas, yo diría que inclusive
I think we were expecting more appeals than those that than what we got. 108 lawyers representing more than 4,000 victims and only 9 appeals. This is something that I've been asked a number of times, and perhaps this is the right place to address it. The impact of the ruling, well, what an appeal does, it kind of leaves it in a suspended state, whereby the sentence is halted or suspended and thereby its effects. So the question is, if the effects are suspended or halted, then what happens with the projects that are being ordered by the sentence? So again, the sentence issues 131 orders, some of them subject to the sentence being applied. There are institutions that need for the sentence to be firmly set in order to start executing those projects. But what about the projects that are already running? There is an opinion that was issued recently about being able to monitor and verify those projects. If you think of the discounts that are kept in mind in the sentence, they are before issuance. There aren't any discounts after issuance. Remember, in the ordinary system, as per Law 65, there is a discount during the execution of the sentence. And the discounts here don't happen after the sentence, only before the sentence. Also, we're looking at a precedent that exists already at the Special Jurisdiction for Peace, which is to look at what is being appealed of the sentence, which would be halted, and what is not being appealed can indeed continue to move forward, especially to ensure that the restorative component continues to be applied. So many people who are watching us don't understand the TOAR acronym you've mentioned. So there are 2 components of the sentence. There's a non-prison sanction that is 5 to 8 years of social work and social activities, but not restriction of liberty. Also, there's a restriction to being able to live and move around a specific geographical surface or area, but we go one step beyond and think of this restriction being meaning that the person who has appeared to be accompanied by someone for the 5 to 10 years. But what is TOAR? It's work and activities that seek to repair, that are set to happen in rural areas and urban areas as presented by the statutory law that is non-taxative. But the principles here are to, of course, observe that statutory law, but also, as Ana mentioned, in serving the victims. So the 2 sentences come together in that regard. There are initiatives which we are aware we have no way of applying them, but this doesn't mean we cannot incorporate them or deny it, as we cannot deny them. We can deny them as part of the sentence. They need to be incorporated. Thank you for those comments. I have a very specific case, a question for case 01. In applying the sanction, there's the issue of political participation. So how can the sanction be adhered to? and then having some of these appealing parties be able to run for publicly elected office. Well, there's one of the very important points of this accord, which has to do with the right to participate in politics. But this led to modifying Article 20 of our Constitution, but the statutory law in Article 30 and Article 129 also sets forth this very spirit. If we think of these three regulations, there's a convergence around the fact that imposing the sanction does not mean that there's an inability to participate in politics. So from a regulatory perspective, there's no option. It's almost as if it could be as extreme as thinking you cannot disable the appearing parties from participating in politics. And also a hindrance, I mean, it's not a hindrance, but we need to go in and look at the issue of compatibility. At the time, the ruling allowed us to think about this issue of compatibility. So how can we think of this compatibility when it comes to applying the sanction and being able to run for publicly elected office? Well, basically, this means we need to set forth two main rules. First, that the sanction and applying the sanction comes first, and that it cannot be conditioned to the ability to participate in politics. And I'll give you a practical example. If there's an appearing person who is currently doing social work in any region in the country, and they say, I need to go to a political meeting. No, they first need to pay their sentence or their sanction. So being able to abandon that perimeter and have authorization to abandon it needs to be duly authorized. And then political participation cannot produce attitudes that victimize victims all over again. And these two need to come together. The laws that I'm referring to in the statutory law specifically sets forth that the sentence cannot ignore compliance with the peace agreement. So the sentence talks about work schedules, for example. But if you look at the issue of the comparecientes, this is set forth by the legislative act, but also the sentence, that they need to serve in processes of reinsertion, social reinsertion and reincorporation. Some of them have gone back to their families. So yes, they need to pay their sentence and be in the process of reincorporating to civilian life, but also should be able to participate in politics. Indeed, there's the ARN instance and how they have to sign that. Indeed, you said it in the last portion of your question. And this is something that we've been asked a number of times. There are elections next year. Whether they would continue to run for office or not is not ours to decide, but the people, if they decide to vote. We'd like to hear from you now. Chair. Well, let's see. I think there's an explanation that is general in terms, but we should keep in mind. So we often talk about those who are responsible. And there are very few, actually, what we call máximos responsables, both at the law enforcement level as at the FARC level. But what's the design? The design is to have the special jurisdiction for peace focus on these specific people. What this means is that the truths afforded by the máximos responsables are usually truths on the patterns and the general policies. And so many victims, going back to your question about the victims, if a victim were to come forth and say, I think that those chief responsible individuals, they should provide clarification on how my father was abducted and what happened to him. They wouldn't know. They wouldn't know because that's how the organizations work. So those who are at the top They don't have information on everything that happened unless it's a very prominent case. So that's the one answer. And then those that are not chief perpetrators need to contribute to learning the truth. And they need to continue doing so. It's part of the conditionality regime. But the truth that the victims pursue is the truth on the case or of a specific case. But that truth you would need to get from those who are not at the top. And to have those hearings with these people, well, they have been there and they have provided some answers, but it's been a slow process. So again, it's about this demand for truth. And many of the comments that we hear from the victims, which are, of course, understandable, well, that truth is held at, say, the middle and lower levels of the command. So this is just to say that the truth is going to be uncovered not just by the sentences, but it's going to be a very long process. Now, what is made clear in the sentence and why is it so valuable from a symbolic standpoint? Because the victim's suffering is narrated, is told, is recounted. All their suffering is recounted in the sentences that, like it had never been recounted before. Their ability to go to the bathroom, their menstrual cycles, the suffering that they were subjected to during abduction is all contained in the sentences. And this is just to say that this is not where our work ends. We're still working relentlessly to uncover the truth, and there will be more scenarios for the victims to participate. Another question to you is, how do we recognize and repair specific damages to women, minors, sexual violence, land grabbing? Who would like to refer to this topic? So I'm going to tell you a bit about how we worked around that for the first macro case. The approaches are very important. Let's keep in mind that there is the gender approach, the ethnical and racial approach, the gender approach, if I mentioned it already. And if you are to read the chapter on damages, the victims are clearly characterized in that chapter based on gender, socioeconomic income level, and then all the damages that they could have suffered if you keep in mind the criteria behind the different approaches. And based on those, then the restorative project is built. A very big value to the sentence and the sentences goes back to what Dr. Alejandro mentioned, which is to show the damage in a very clear and even sometimes raw way. To some extent, making something that is quite intimate, very public, which, yes, could be criticized, but we try to do that in a sentence just to make that truth be known. And it's almost quantitatively determined what the impact was on young men and women, girls, pregnant women, and the different ages of the victims. And the pursuit was to meet a very big principle related to representation. In other words, to rebuild or reconstruct the phenomenon and be able to gather all of the experiences coming from such a complex universe of victims, again, more than 4,000 victims. So it was about verifying facts or events that can be considered to be emblematic, which represent certain narratives in which many victims can see themselves based on events and facts.
So in the ruling, in the chapter on transitional restorative justice, we have an analysis, first off, of who the victims were, what they lost. There's a characterization of these damages. We have, in fact, a telling of that story from their perspective, and then we get to the reparations. When we looked at what was to be repaired, we looked at many reparations models and systems. In the ruling, we looked at how reparations are made in the inter-American system, and also how it is done by the ICC, and also how it is done by the WADIV, to look at how we might make a contribution in order to make a contribution to the victims' reparations. And so here, we do things differently to how things are done in the ICC, in the Inter-American system, or in the WADIV, which is the unit for attention and comprehensive reparations to victims. What we found is that there are systemic damages made based on illustrative facts, and this is what enabled us to reach our conclusions. And we have to, or we cannot dictate reparations for each specific occurrence. So that's why we dedicated so much time to listening. We do have some reparations limitations, as I see it, in the jurisdiction. What can we do to ensure that the perpetrators contribute to the reparations? And in the ruling, there are several main axes: memory and dignification. The victim said, we would like to have our families' good standing held in dignity. There's also another important element of productive projects and income generation, because victims lost their productive projects. And we also have community infrastructure construction projects. It's not that they're after big highways or anything like that. We would like to have community infrastructure, healing centers, mental health centers, community houses, and also areas or in facilities that youths can visit and request information. And we also have transgenerational issues. And we have some victims who were still in their mother's stomachs when their parents fell victims to these crimes. And they were told about this by their aunts and uncles or their grandparents. So this is all addressed in the ruling, and there's also a very strong emphasis on women who are seeking disappeared persons, because here we have mothers and sisters who continue to search for their loved ones. Those of you who saw the verification hearing, you may remember one of the sisters who spoke about how her mother died while she was looking for her son. And so this woman and her siblings inherited this search. So this woman has been wearing black for 22 years. It's permanent mourning.
hay un énfasis fuerte en los enfoques. Una de las cosas que
And so here,
traemos en la decisión, no necesariamente
we,
como fuente para calificar estos crímenes,
it's not about,
sino
let's
como,
say,
pero sí como una
qualifying
fuente
these
para decir
crimes,
que también en los
but
territorios
it's also
indígenas,
about understanding how in
en los
indigenous
sistemas de justicia de los
territories,
pueblos indígenas,
indigenous
tipos de
justice
crímenes
systems
eran,
do address these kinds of crimes,
eran
but
muy graves.
these crimes were seen as incredibly grave.
El pueblo Wiwa,
Here we have the
Canguamo, y de
Wiwa,
los dos procesos
Canguamo
comunitarios que están
justice
allí en el
systems,
caso,
as well as the
también
two
en un
community
sentido de
justice efforts
reivindicación,
there.
pero también
It's
para
about
nombrar lo que pasó
reivindication,
y para
but also
decir que
about
eso
putting
que
a name
pasó
to what
tampoco en esos
was
sistemas de
done.
justicia estaba bien, ¿sí? Que estos son crímenes graves
And so
en esos
these are
pueblos en donde la violencia
grave
es grave.
crimes.
Se nos
And
cumplió el tiempo,
this is
pero
where
yo quisiera saber, magistrados y
life sanctity
magistradas,
has not
si
been
permitimos
respected.
una o dos preguntas más con
I don't know if
respuesta
we might
corta
have
para tratar
time
de abordar,
for
porque
one or two
igual
more
se nos van a quedar varias
questions.
por fuera, pero hay
I know
dos
that we'll still
y
miss
ustedes
several.
verán quién la contesta para poder avanzar.
And
Una
so
es, ¿qué pasa
let's
si
see how
por
we
el
can
motivo los
respond.
comparecientes no cumplen
What
la
happens
sentencia
if the
restaurativa?
perpetrators do not fulfill the
Y dos,
restorative
de una vez se las planteo,
sentence?
en el caso que usted
And
ha mencionado,
secondly, in the
¿qué
case that you have
lecciones cree que
mentioned,
pueden
what
recoger
lessons
como el
can
sistema
be learned
interamericano de derechos humanos,
from the
la CNI,
inter-American
la Secretaría
system, the
Internacional, de esta
ICC?
valoración que ustedes han estado haciendo sobre la
Because of
pena,
course you've
¿no?
been
Porque ustedes acaban
evaluating
de
what
explicar
kind of
lo que
sentences we could
significa
have.
tomar esta justicia restaurativa y hacer de la
So it's
pena
all
una
about
pena restaurativa, y eso pues qué
how
lecciones se puede
to
dejar al mundo. A ver si con
sentence and
estas
have a
dos
restorative
cerramos y ustedes me dirán
sentence.
quién las quiere contestar.
So perhaps you could answer.
Vamos a ver para ver cuál contesta.
Let's see.
Entonces, sobre lecciones aprendidas
When it comes to lessons learned,
y sobre todo, yo creo que aquí una cosa que no se nos puede olvidar es que,
I think that
y yo
one
creo que
thing
a
we
las
cannot
víctimas
forget,
después de la JEP no se les va a olvidar, es
and
que
I
la
don't think the victims will
participación
ever
es
forget this,
fundamental y es
is that
posible. ¿Sí? Los
participation
sistemas
is
de
fundamental
justicia en
and
el
it's
mundo y en
possible.
Colombia
If
tienen
justice
que
systems around the
entender
world,
que quienes son
justice systems
dueños
in
de la
Colombia and around the
acción
world
son
have
las
to
víctimas
understand
y
that
que a las víctimas hay
victims
que
are the
preguntarles
owners
y
of
que
these
ellas deben estar al
actions,
centro
and we
de
have
sus
to
procesos. Y yo creo
place
que eso es
victims
un
at the heart of these
aprendizaje no
processes.
solamente para
So
nuestra
this
justicia,
is
sino
not
para
only
estos
a lesson to
sistemas
be
de
learned for
justicia.
our justice system,
Y
but for all
el otro
others.
asunto es en relación con la proporcionalidad de la pena.
And of course, it's about
Yo creo que
proportionality of
tampoco
the
podemos
sentence,
perder de vista
but
que
I
es que
think it's also
los
important that we do not
comparecientes que llegan
forget
a estas sanciones no
that
llegan,
the perpetrators
pueda
who
usar
receive these
un término
sanctions,
coloquial,
let
de
me use a
gratis.
colloquial
Es
term
decir,
here,
los
they're not
comparecientes
there for
que
free.
acceden a una sanción propia
Those
es
appearing
porque
parties who
han hecho
accept special
aportes a la verdad,
sanctions do
¿sí?
so
Porque
because
han decidido
they have
no
made contributions to the truth,
estos
because
hechos
they
y porque
have
han
made a
decidido
decision
contribuir a la
not to repeat
reparación
these crimes,
de
and
las
because they've made the
víctimas.
decision
Y
to
entonces aquí la
contribute to
pena no
victims'
se valora
reparations.
en
So
clave
here,
de severidad o de
the
años de
sentence is not
cárcel,
about
sino en
severity or
clave
number of years in
restaurativa,
which
en
the
clave de
person
que
goes to
la
prison, but rather
sanción
it's
tenga un
about
significado para las víctimas,
restoration
contribuya
and about
a
the meaning
dignificarlas,
of
a
these
repararlas
reparations for the
y hacer
victims, so they can have
transformaciones en el
their
país y contribuya
their
también a
dignity
que los
reformed and make
comparecientes a partir
contributions
de
to the
esto
country.
hagan una
And
transformación
the idea is also for the
y se
perpetrators to be
dediquen a futuro
transformed
a
and to
tejer esos lazos que se rompieron por el
help
conflicto.
to
Entonces,
rebuild those
en
ties
ese
that were
sentido, creo
destroyed by
que
the
también
conflict.
creo que esto es una lección importante
So I think that this is a very
para el
important
mundo, creo
lesson
yo,
for the
si
world.
se piensan las penas no desde
I
el
think we
lugar de
need
la
to think
cárcel, no como
about
venganza,
sentences in this
como
way.
nos
It's not
decía
a
el día
form
una
of
víctima,
revenge. It's not
sino
about
como un
imprisonment.
lugar que les permita
It's a
hacer
sentence
transformaciones
is about
desde
creating a
adentro
space
a
from
las
which
personas que cometieron
transformations
estos crímenes y
can
que
be
sean
made from
conscientes de
within.
que
From
una
within those
sociedad
people who
puede
committed the crimes.
recibirlos
And
nuevamente,
the
como
idea
pasa en los
is
pueblos indígenas, si
for
hacen esos
society to
compromisos de
be
hacer
able to once
aportes a la
again
verdad
receive those
y contribuirse
perpetrators to become societal members once again,
a
just as is
sanar
done in indigenous
eso que dañaron.
peoples.
Y
And the
entonces
idea is
hay
for them
otra
to
lección,
heal
y es
what
que
they have
si
damaged. So there's
un
another lesson
sistema
learned there.
como
If
el
a
occidental
system,
puede recibir lecciones y apropiarlas de
so
los
here
sistemas
that we're saying that the
anglosajos, ¿no?
Western world can learn
Bien,
from
Yo
indigenous
yo
justice.
complementaría lo que
Am I right? Yes.
indicaba Ana, que
I would like to add to what Ana has said. I think that special sanctions here represent an enormous national wager, and it's unprecedented. So if we look at comparative law, there is no kind of similar sanction system. This is a huge wager that's being made, but it's still open to discussion. And for us, there's an academic discussion because there's also the political tint. We need to have those discussions too. But I think that special sanctions offer a new possibility to rectify, to repair these crimes. When we look at the crimes that occurred in the conflict, it's about the state responding with a special sanction. How do you weight this? As Anne has said, it's about looking at the restorative aspect, not the aspect of retribution, because having a retribution-based sentence, and this is something we've understood in the court rather than in legislation, it's about satisfying, let's say, or there is a discussion still open as to about whether or not there could be a retribution-based component. But the idea of a sentence in the ordinary system is to prevent future crimes. But here we are aiming at a different goal. It's about peace. It's about guaranteeing victims' rights and repairing our social fabric. So here, we are not here to discuss the law of Thalion. And here it's about victim centrality and looking at how we can turn this formula on its head. Here, the harm caused is placed at the heart of everything, and it's about how we can make reparations and also offer opportunities for incorporation. And if there are cases of appearing parties who have not fulfilled these sentences, well, yes. There are several regulations, even in the peace agreement itself. But when we talk about special sanctions in Article 127, where it talks about rights restriction, there's a word that's very, very important for us, culturally speaking. And it talks about legitimate trust and good faith. And so all of these sentences are to be fulfilled based on those values. And I think that time will show whether or not that principle is honored. As I said, the appearing parties have been involved in this process for 7 years already. That's part of honoring that principle. But yes, there are other regulatory remedies. And in the instance of a breach, then we would look at what to do. The restriction element could be intensified or the type of sanction could be changed. But yes, there are regulatory responses to breach of sanctions. And so if an appearing party does not fulfill their sanction beyond the legal remedies we have, I think it's about looking about all of the restorative efforts that have been made up to that time. And it's about, first off, recognition of crimes, and then in the verification hearing, the appearing parties appeared before the victims and the country and entered into a commitment to contribute to reparations. If you remember, when we had the verification hearing, we called them and we said, do you agree to making a contribution to reparations? That was the question we asked them, and the majority of the perpetrators came up to the front of the hearing and said, yes, we are willing to do that. And they responded to the jurisdiction that they were willing to contribute to reparations and to engage in restorative projects. And I think that if an appearing party says that they are not willing to honor their word, they would be, of course, dishonoring their agreement, and they would not be acting in good faith. A path has been paved, and we hope that that path will be honored.
I know you're about to wrap up, and this may seem evident, but of course, these are the two proponents for both cases 1 and 3, but there are 4 justices and
decisión.
they need to be,
Realmente fue un
well,
desafío,
recognized as
de
having
la audiencia
participated
de
in
verificación
issuing
a
this
la emisión de la
ruling
sentencia
and this
nos
challenge
impone la ley,
from
que
the
son 20 días
verification
para emitir
hearing to
sentencia.
issuing the
Pero
sentence.
el
It's a
macrocaso, la
20-day
dimensión del
period,
macrocaso,
the macro
logramos
case,
hacerlo
and
incluso en
it's in
25
its full
días, pero
dimension.
cumplimos con
Well,
todo el
it took us
compromiso. De
25
manera,
days,
no
a bit
solo es
more,
radical la
but we
ponencia, sino
still
discutirla, darle
fulfilled
y creo
what
que
is
como
set forth
jurisdicción,
by
como
law.
sección,
As a
fue un gran trabajo
jurisdiction
que
and as a
queremos reconocer a los
section,
colegas.
I think
Y
this
otro, sé
is
que aquí
the
el
result
secretariado
of
recogió a nuestros
very
equipos
good
de
work.
trabajo, todo nuestro
Also,
reconocimiento
our
por ese
teams
compromiso,
need
ese
to be
profesionalismo y ese
acknowledged
gran
for their
trabajo que
commitment,
realizamos. Muchas gracias.
how professional and how dedicated they have been. Thank you so much.
Ya. Bueno, entonces, sí, adelante, por favor, magistrada.
By all means, Chair, I simply would like to, well, wrap up and say goodbye. I think this was a very fruitful conversation. Universities are very important think tanks and centers that bring together the different parties for a conversation, for a dialogue, and also to be critical and self-critical. And of course, there are many students of law here. And what I suggest is that you study the ruling. It's very easy to raise your hand and give an opinion when you haven't read the ruling. So also, as a teacher of law, don't take anything for granted. Go and read the ruling is my suggestion. But Justice, before we wrap up, and again, thanking those who have summoned us here this morning and afternoon, I think perhaps it's a good time to communicate a message to the country. As you've mentioned, we're entering an electoral year and there have been attacks against the special jurisdiction for peace. I go back to 7 years back when this special jurisdiction was being built. Yes, indeed. You are self-critical. And the country, of course, is also analytical and critical of your work. But what would you like to communicate of what has been done thus far and what is yet to be done by the Special Jurisdiction for Peace? Well, what I would say is we are the result of what was agreed upon in the peace agreement. Based on our work and our knowledge, we have done our best. We have done our best to push that agreement forward. In this, I dare say we have been very innovative, very open to listening to the victims, to create many mechanisms that those who signed the peace agreement didn't even think could be imagined. No one really fathomed what it meant to extract the truths of these conflicts and the realities that we have had to confront and which we have confronted tirelessly. And most FARC ex-members are demobilized. Let's not forget that. Yes, of course, there's Clan del Golfo, the spin-off groups, but what would our country be like right now had they not demobilized? What would our country be like right now? And they're still demobilized, even though they're getting killed, more than 180. So what country would we be in today if these 11,000 that laid down arms hadn't laid down arms? Well, thank you very much to those who summoned us. Thank you to the audience who supported us. We tried to answer all of your questions. Very few of them went unanswered, and we continue to welcome these opportunities to continue talking about the JEP's special sanctions. Thank you so much.
Llegamos así al final de nuestra jornada.
So this brings us to the end of this conversation on the JEP's rulings, an academic conversation on the meaning and the impact for peace building. We have been able to foster a very important dialogue to reflect upon the progress and the challenges in the issuance and implementation of special sanctions. And we have been able to examine the sense and the meaning and impact of these rulings issued by the Special Jurisdiction for Peace and how they have contributed or will contribute to peace building. We want to especially thank those who made this opportunity possible, meaning the Kroc Institute, ILAPS, and Notre Dame University, and of course, Externado University in Colombia. To the justices, Alejandro Ramel y Ana Manuela Ochoa and Camilo Suarez, thank you for sharing your experiences. And to Hernando Parra Nieto, the president of Externado University, also Ángela Ramírez and Gloria Castrillón for moderating this panel. Thank you. We also want to thank you for being here, and those who followed us online also thank you for joining us via social networks and our digital platforms. We hope to see you again very soon. Thank you.